Hello, everyone, and welcome to our Total Medicare Compliance webinar. We're going to get started here in just a couple of minutes. Our CEO, Jason Lazarus, is going to be presenting the material to you guys today. Almost everything you wanted to know about Medicare, but we're afraid to ask. So I'm going to turn it over to Jason here in just 1 minute. But first, I'd like everybody to take a look at your control panel. You can see on the side there's a couple options you have. One of those, there's a field that says questions. If you have questions during the presentation, just type those questions to me. I'm Susan. I work in marketing here at Synergy. And what I'll do is I'll forward your questions on to Jason, and he'll get with you just after the presentation and answer those directly. Another thing we wanted to let you guys know is you don't have to worry about taking notes today. We're going to make the PowerPoint available. We're also going to make this recording available, and we'll send that to you guys via email by the end of the day. So Jason, you want to go ahead and get started?
Thanks, Susan. When we founded Synergy, the idea was to put together a comprehensive set of settlement services to allow trial lawyers to focus on what they do best. And Medicare compliance is something that diverts your attention from being a trial lawyer. So today's presentation is meant to educate and allow you to issue spot the Medicare compliance issues that can arise in your practice and hopefully avoid the pitfalls that can be present in this particular area that is continuing to evolve. And it's very timely right now because of some things that have developed that I'm going to talk about later on in the presentation. First, I just wanted to start off with just a little bit of a review about the basics and the interplay between SSDI and Medicare. SSDI is the disability payment that Social Security provides to those that become disabled, and Medicare is typically the healthcare provider for those that reach retirement age, but through disability, people can get Medicare coverage early. Neither SSD or Medicare are income or asset sensitive. They're entitlements. We fund those benefits by paying into the system. And so if a personal injury victim has enough quarters paid into the system and becomes disabled, they become entitled to SSDI. And SSDI is the gateway then to Medicare. And the way it works is there's a 6-month elimination period before you get your first SSD payment, and then 24 months thereafter, you become a Medicare beneficiary. And that's why there is a subset of the population that you have to be concerned about whom you represent if they've got a reasonable expectation of becoming a Medicare beneficiary within 30 months, which is anyone that has already qualified and began receiving SSDI payments. So there's different types of Medicare coverage. The traditional Medicare coverage is Part A and Part B, which covers hospitalization and medical expenses. Part C is Medicare Advantage Plans or Medicare HMOs. These are run by private insurance companies, but they've been approved by Medicare and partially funded by Medicare. What becomes problematic is that people can go between Part C and Part A and Part B. So you could, in theory, have a client who started out on Part C, then went back to A, B, and that presents a whole host of issues that can arise in the context of liens and also Medicare set-asides, which I'm going to cover later on. And then the last part is Part D, which is prescription drug coverage. That is rolled up into Part C if a client elects that. If not, they will have traditional A and B and Part D. So according to Medicare, under the Medicare Secondary Payer Act, there are two obligations. One that goes from the date of the settlement backwards, which are conditional payments that were made on behalf of the injury victim that should have been made by the liability insurer. And then there are the Medicare set-aside issues that are from the date of the settlement forward, which is futures. Now, one of the important things to take away from today's presentation is that Section 111 is an important piece of the puzzle. Section 111 has been implemented over the past 5 or 6 years, and it requires defendant insurers to report to Medicare when they settle a case with a Medicare beneficiary. So what this does is allows Medicare to identify situations where perhaps a conditional payment was made and reimbursement was not done. It also identifies any settlement involving a Medicare beneficiary for Medicare, and there's a whole host of information that's reported, and I'll talk about that in a little more detail when I talk about Medicare futures, why it's important. But this particular aspect of what is now the law for defendant insurers is important to remember, because they will incur penalties if they don't report, and that's why you will see the inclusion of a tremendous amount of Medicare secondary payer language in releases. A lot of that is inappropriate and incorrectly drafted or inaccurate references to statutory provisions or regulations. So you have to be really careful about the release language that's being included in the release as a result of the fear that surrounds this law. But all this law is a law that requires the reporting of settlements with Medicare beneficiaries. But it is done electronically by the defendant insurer, and it's a data dump. It's a tremendous amount of information that goes to Medicare when a case is settled. So with that little summary about Medicare and SSD, I'm going to now focus on the issues that arise from the date of settlement backwards, which are conditional payments. And then I'm also going to talk about Part C Medicare Advantage liens, because that's an evolving area of law and something to be very concerned about when you resolve a case that involves someone that has been or is on Medicare. So when there is a traditional Medicare component to the case and Medicare has made conditional payments, there's a couple of different options to resolve that obligation. One is simply pay the amount that Medicare says is due via the final demand. It's very important to make sure that you pay from a final demand and not a conditional payment letter. The CPLs, as they're known, are not something that can be relied upon. I saw a case recently where a plaintiff was trying to claim that they relied upon the CPL, but the CPL says it's not to be relied upon. It is just an interim figure. You have to give the settlement figures to the BCRC, and then Medicare will issue the final demand. And then if you don't pay within 60 days, it begins to accrue interest, and it eventually is referred over to Treasury for collections. If there is unrelated care, or if you're disputing the amount that Medicare has owed, you can go through the Medicare appeals process. We don't recommend going through that process because it's a very lengthy process, and once you begin the appeal process, interest starts to accrue, and it's over 10%. So it's really not an effective way to deal with the issues that may arise with conditional payments that perhaps are incorrect. There are other ways to do it that are post-final demand, which is through the compromise and waiver process, and there's 3 different ways that plays out, or 3 different areas of the law that you can utilize to get a waiver or compromise. The first is a financial hardship waiver. The second is the best interest of the program waiver. And the third is under the Federal Claims Collection Act. So all of these mechanisms, if they are used successfully, Medicare will actually cut a check back to the client. So these are after final demand has been paid to Medicare, and then Medicare issues a check in a refund format back to the client. What's really nice about this is that you can go back and get a refund on old cases. There's no statute of limitations, and it's a great PR move for your firm if you've got cases that have been resolved and you are able to go back and get a waiver compromise for a client and they out of the blue get a check back from Medicare. That's certainly something that most clients are going to very much appreciate, and it is possible, amazingly. And this just gives you a little bit of information about our program that we have instituted to assist clients in getting refunds back from Medicare. So when we go down this road and assist clients with getting a Medicare refund, our success rate is 73%. Last year, we saved almost $1 million or obtained $1 million in refunds for clients, and the average refund amount was $30,000. And as you can see, some of these refunds are quite large. And one of those rather large refunds was in a case that had a client who received a 7-figure settlement, and we were able to successfully use the financial hardship waiver, even in a 7-figure settlement situation, to get a refund back from Medicare. So this is a very viable tool to deal with cases where you don't want to go through that appeals process and there are issues with the repayment of Medicare because, say, there's caps on damages, liability issues, and you don't get a full recovery for the client. This is the perfect vehicle to get a refund or any other situation that fits within the parameters of the different methods for securing a compromise and waiver. So moving away from conditional payments and into Part C Advantage Plan liens, this is really problematic because of the fact that you can have a client who you know is a Medicare beneficiary and you request a conditional payment amount from Medicare. They give that to you and you get a final demand and you pay it, but that client during that time period also had been in Part C. Medicare will not tell you about an Advantage Plan lien, so you will not know about that lien. And if you don't know about that lien and don't satisfy that lien, it can become a real problem. And I'll explain why, or you'll see why in a moment. So the Medicare Advantage Plans, sometimes called Part C and MAOs, are basically standing in the shoes of Medicare when they are elected by the Medicare beneficiary to provide benefits. These plans, the law that's developed, really have the identical rights to recovery as traditional Medicare does. And the MAO plans use the Medicare Secondary Payer Statute as the basis for their recovery rights. So the way it works is the same as it works with Medicare, and it's basically a reduction for procurement costs. And you guys probably are all familiar with dealing with these formulas and how sometimes they're really problematic when the client's monies are not sufficient to pay back Medicare. So you're dealing with all the same issues with a Part C provider. So what really becomes troubling is, in this area, is the regulations and the Medicare Secondary Payer Statute that allows for a Medicare Advantage Plan to bring a cause of action for double damages. And everybody has always feared this or talked about this in the context of Medicare, and it's never come to fruition. But in the context of Medicare Advantage Plans, it now has. So if you look at the statute and the regulations, what's really troubling for attorneys is their own personal liability in situations where a Medicare Advantage Plan has made payment, because those statutes and regulations allow for a double damages actions to proceed against an attorney. In the case that I've got down at the bottom, Humana versus Paris Blank, that's exactly what happened. The law firm was sued directly for the amount of the lien, which was $191,000 times 2. So in that case, the lawyer that runs our lien resolution group acted as an expert on behalf of the law firm. So it illustrates that these advantage plans are becoming very aggressive about enforcing their rights under these statutes and regulations. And the case that emanated out of here in Florida, the Humana versus Western Heritage, is illustrative of the problems. And in that case, Western Heritage did really everything they could to try and make sure that the Medicare Part C plan was reimbursed. They actually had put the Part C plan on the settlement check, and the plaintiffs fought that and won, and Western Heritage tried to go through the trial court to make sure that the reimbursement was going to be made. That was unsuccessful, and basically the case wound up going through the levels through the Federal District Court and ultimately to the 11th Circuit Court of Appeals. And basically the crux of it is that it was held Western Heritage had the obligation to independently reimburse Humana even though they had paid the plaintiff, and because it didn't, the court found that as a matter of law they were exposed to double damages. And that same idea goes for the plaintiff attorney. The advantage plan could have gone after them as well. So it's a cautionary tale about making sure that not only do you double check that conditional payments have been properly paid from a final demand, not a conditional payment letter, but that you're investigating whether there's a Part C plan, and then also negotiating that to make sure that there's not these sorts of issues hanging out in your cases. So now I'm going to transition to talk about Medicare set-asides and futures and the whole conundrum that has confused many and still is a source of confusion amongst the defense. What really is critical is to understand that this really is a plaintiff issue. The defendants don't have exposure under the Medicare Secondary Payer Act as it relates to Medicare set-asides. If a client doesn't set aside monies, the only potential ramification of that is that Medicare will refuse to pay for future injury-related care. That's it. So as a plaintiff attorney, your primary concern is making sure that the client understands what the issues are ultimately. And I think at the end you'll get a flavor for how we approach it and how we recommend approaching it. But one of the key takeaways from today about this specific issue is that you only have to worry about this issue if you're dealing with a current Medicare beneficiary or someone arguably that has a reasonable expectation of becoming one within 30 months, so those that are on SSD. As we sit here today, there isn't any regulations or statutes or case laws that require a Medicare set-aside, but I'm going to talk later in the presentation about some recent developments and the way things have been moving in a direction towards a codification of Medicare set-asides. But as we sit here today, in my opinion, it's akin to special needs trust. So when you settle a case for a Medicaid or SSI recipient, you have to explain to them that there's a trust that can be established for their benefit that can hold their settlement proceeds and protect their Medicaid entitlement. And now really it's the same thing with Medicare set-asides, because it is a tool, a mechanism to protect their future Medicare eligibility, and if they don't do it, there is a chance that they will have Medicare refuse to pay for injury-related care. The good news about how things have developed is that an MSA can be used as an offensive tool to set the floor on medical damages. So I wanted to go back for a second to the mandatory insurer reporting, the MMSEA, which I talked about at the beginning, because it becomes important as it relates to futures, and there are also issues that relate to conditional payments and liens. So when a case is reported, the reporting includes ICD-9 codes, and that allows Medicare to identify what is injury-related care or not going forward. And so the issue that can arise as it relates to futures is, say you have an auto case where there's an allegation of neck and back injuries, but throughout litigation, the defense takes the position that the neck is pre-existing and refuses ultimately to pay any dollars for that specific injury, and the case resolves, and the defense reports the settlement to Medicare under the mandatory insurer reporting, but reports the neck and the back. So then Medicare now has the ICD codes related to the neck, which arguably should not have been included because that part of the claim was denied. But importantly too, with liens, the conditional payments, when the defendant reports, if they report the wrong date of accident, that can be very problematic, or they report the wrong ICD codes, say they include pre-existing conditions. If they report the wrong date of accident, that can trigger the issuance of a second final demand, and we see that quite a bit in our lien resolution group where we're having to go back and fix those issues. They report the wrong ICD codes, obviously that can trigger a denial of care. So it's very important to make sure that you document what the defense is going to report. Either include the ICDs as an agreement in the release, what's going to be reported, or in a separate written agreement. You don't have any way to see what is reported to Medicare. It's done electronically, as I said earlier. You can't get a copy of it, so you have to be proactive about dealing with the defense on this particular issue and make sure that you know exactly what's going to be reported, or it can cause some problems down the line for the client. And as you can see, the reporting requirements are basically every settlement, because it's settlements over $1,000. And so that's been reported since January 1 of 2015. There was a phased-in approach where defendants only had to report certain dollar figure settlements, but now it's gotten to full implementation, which requires any settlement of $1,000 or greater to be reported. So the question is, why is all of that so important? Well, when I was talking about those ICD codes triggering a denial of care, if that were to happen to a client, they are going to have to go through a lengthy internal appeals process before they ever get to see a appellate court, federal district appellate court. And I was just again reading a case pretty recently where somebody was trying to get a federal district court to hear a conditional payment dispute and alleging that that was proper for the federal court to exercise jurisdiction. But there are a ton of cases out there that say you must exhaust this internal appeals process before a district court can take jurisdiction and hear the case. So that's why this becomes very important, is because if the client does get denied care because of what was reported by the defendant insurer, there's a very long road ahead to try and get that resolved. So you want to deal with it on the front end, and you want to make sure that you address the set-aside issue somehow, some way. And in the end, that idea of protecting Medicare's interest doesn't necessarily mean that monies are set aside. It means a thoughtful, thorough legal analysis of what should be done. And by the time I get to the end of this part of the presentation, I think you'll have a good idea of what that sort of means. But Medicare's position about Medicare set-asides comes from the agency's interpretation of the Medicare Secondary Payer Act, which they are charged with implementing. And basically the Secondary Payer Act just says that Medicare is supposed to be secondary to all forms of insurance, which includes workers' comp, liability, and no-fault insurance. So with that background, I want to talk a little bit about just the basics of MSAs so that you've got a good understanding of what it actually is. But really, it's pretty simple. Basically, it's a big deductible for the client. You're carving out an amount that would be equivalent to the amount of future Medicare covered services over that person's lifetime that's specifically related to the injuries suffered in the accident that is being settled. And the way an MSA is calculated is it's the injury-related medical expenses plus prescription drugs, because Part D covers prescription drugs, over remaining life expectancy is what the allocation amount is. So an allocation amount or an allocation report is basically a life care plan that outlines what the future Medicare covered expenses related to the injuries suffered, including prescription drugs, is. And there's an important point about rated ages, and rated ages are used in structured settlements. And why it's important here is because Medicare accepts rated ages as evidence of a reduction of life expectancy. And so going back to the previous slide, because it's calculated over remaining life expectancy, it's important to make sure that a rated age is utilized and is utilized aggressively, because that lowers the amount potentially to be set aside. And once perhaps an apportionment or reduction formula is applied, nothing is set aside, or there's an analysis of why other damages are so significant that really future medicals are not funded, it becomes important in that respect. So this area has traditionally been regulated by Medicare via policy memorandums. And I say this area, that's workers' compensation Medicare set-aside arrangements. And a very detailed set of instructions have been developed. In liability cases, that's not the case. So there's been a few sporadic things that have come out over the course of the last 5 or 6 years. And I'm going to go through those quickly just so you've got a kind of a background for what's going on today as a backdrop. So back in 2011, we had a regional memorandum, a regional coordinator issue a memorandum that really summarizes pretty well how Medicare views this area, which basically it says that there's no difference between a workers' compensation and liability case when it comes to protecting the Medicare trust fund, and that the agency believes that a set-aside is the best protection for the program and the Medicare beneficiary. Of course they say that, because that's what protects the Medicare trust fund from paying in the future. But what's important about this memorandum is it talks about the funding of future medicals and the responsibilities of the parties, because one of the first important questions in figuring out whether you need to go down the rabbit hole of the Medicare set-aside and the analysis is, are future medicals funded? Because if the answer is no, then there is no Medicare set-aside issue, even if the client is a current Medicare beneficiary. Because the key is that you have to have future medicals being funded and then avoid the shift to Medicare for that future care when you're receiving monies for future medical. And that's why there's arguments to be made that if you don't get fully made whole as it relates to the future medical damages, that perhaps there's no need to set aside anything, or perhaps there is much less. This particular paragraph is also good to send to the defendant when they start saying that they're going to require a Medicare set aside, or they send you a release that has page upon page of MSP compliance language, because basically what it's saying about the defense's obligation is that they must notify plaintiff's counsel and the Medicare beneficiary that future medicals are funded, which obligates them to protect the Medicare Trust Fund, and then report the settlement under Section 111. That's it. So you can certainly use this to your advantage if you're dealing with a particularly difficult defendant insurer who's insisting upon things that aren't mandated or required, because there's nothing, frankly, as it relates to Medicare set-asides that's mandated or required by any regulation or statute. So pages upon pages of language is just simply inappropriate because there is no such law. We do frequently consult and help with issues regarding release language. In our language, we boil it down to one paragraph that deals with Medicare compliance, because really that's all it takes in most instances. It has to be tailored to that specific case because the facts are unique to each and every settlement, but there certainly is no need for page upon page of meaningless dribble, because that's typically what it is. So after that memorandum from the regional office, there was a memorandum issued by the CMS headquarter office in September of 2011, and basically this set up an exception saying that a Medicare set-aside in the liability context wasn't necessary if the treating physician certifies in writing that there wasn't going to be any future need for care. And you might be saying to yourself, well, that's really not a value, and nor do I want to get that in the middle of my case because that kills the medical portion of the claim, which is true. There are situations where you can get that post-settlement. It's not something that necessarily has to be obtained prior to settlement, even if there were claims of medical damages contained in the case. But this also is indicative of the fact that Medicare viewed Medicare set-asides as being necessary because they went ahead and defined when they're not necessary in the context of liability settlements. So in 2012, Medicare or CMS began the process of creating regulations for Medicare set-asides and the Medicare Secondary Payer Act enforcement as it relates to future medicals. And we were very involved in that process through AAJ and through other organizations in trying to give Medicare commentary and developing feedback for Medicare, which they requested about this particular area. And this whole development of the potential for regulations went on for quite some time, and then finally Medicare issued a notice of proposed rulemaking in May of 2014, but then later in October of 2014 they withdrew it without comment. And so it's sort of remained an issue out there that nobody has known really what to do, and there's continued to be confusion. And because of that, there have been some trial court decisions that have arisen, no appellate decisions, that have surrounded the concern of the parties about Medicare compliance. The first case, which really isn't all that important, just Schneckschneider cited the Stalcott memo that I started talking about when I started talking about regulation as law, because there is no real law. So you had these courts looking at things like the Stalcott memo for guidance in terms of what should be done. The next case, Marine Terminals, was a case that's instructive because the parties agreed to a CMS-approved liability Medicare set-aside, which set up an impossible contingency in their settlement because CMS would refuse to review a liability Medicare set-aside in that case, and so the parties wound up having to go to federal district court to get approval of the set-aside since CMS refused to review it. The next case, Sterrett v. Klebart, is an important one in my opinion because what the court did was go through an analysis of the damages in that particular case to determine that future medicals were not funded, which, as I said, is the prerequisite for whether a set-aside analysis needs to be done. In that case, there was a competing consortium claim and lots of other damages that the court felt were sufficient to the point where future medicals really were not funded in that case. The Benoit v. Newstrom case is a case that is very important, probably the most important, in my opinion, in terms of these cases, because it deals with a fundamental problem and flaw with trying to do Medicare set-asides in the liability context. So in workers' comp, where these set-asides developed, you don't have cases that are settled like liability cases are. In those cases, the carrier's on the hook for the full amount of future medicals, and so a workers' comp case will typically these days be settled with a Medicare set-aside plus a payment for indemnity, and the carrier will pay whatever the amount of the set-aside is because they're on the hook for all the future medical. Well, in liability settlements, we have cases all the time that get settled for less than full value because caps on damages, policy limits, liability issues, a myriad of things can result in a case selling for less than full value. So, and say you've got $1 million in future Medicare coverage services, but you've got a $100,000 policy limit settlement. How do you set aside $1 million when you're getting $100,000 gross? The answer is you can't. So you have to have some type of reduction mechanism to do that. And the Benoit case tackled that issue and applied a reduction formula to reduce the MSA. They didn't use exactly what we advise our clients to do in those scenarios, but they came to the same end result. So what our advice is to use a equitable distribution or an Alborn type of reduction where you look at the full value of the case compared to what the settlement amount was. So if you have a case that's worth $1 million, but it settles for $100,000 policy limits, the client is only receiving 10% of their total damages, and whatever that MSA amount is, it should be reduced by that percentage, reduced down to that percentage. The last case is a case that came out fairly recently and has been often cited as a case that says that MSAs are not required in liability settlements. And really what it says is that there isn't any federal law or regulation that requires an MSA in liability settlements, which is absolutely correct. That's what I've been talking about from the get-go as it relates to this specific area. So it really is right on point with what I've been saying. And you have to be very careful about the idea of a statute or regulation requiring this versus the idea of how do you be compliant and how do you make sure your client's protected and how do you make sure your practice is protected. And that's what I'm going to talk about in a few moments. But in the end, the Medicare set-aside is a mechanism to protect the Medicare trust fund. And whether it's utilized or not is really going to be a consequence of the client's risk tolerance and how ultimately they view the risk that they're taking on. But if there is a shift to Medicare of the burden for future medical, and that settlement's been reported to Medicare, there is a real genuine risk that Medicare will refuse to pay for injury-related care. And the reason for that is some of the more recent developments. So last year, the AAJ recognized that Medicare was pushing an agenda to address set-asides. And then late last year, CMS sent out an alert that it was considering expanding its voluntary review process for liability set-asides, which most of the regional offices have refused to review. In the fall of last year, there was a roundtable in Washington, D.C. amongst many stakeholders in the industry, including the AAJ, that was actually put on by the defense side of things, to discuss these issues and try and get some consensus to get Medicare some feedback before they did anything. And then in the end of last year, Medicare sent out a proposal for a new review contractor because Medicare utilizes contractors in implementing the Medicare Secondary Payer Act. And what they requested was a contractor who would be able to review liability Medicare set-asides, and they set up two different types of review, a full review and a cursory review, which is something that was advocated as part of the feedback to Medicare relating to these issues, because the review process for a full review is quite lengthy for workers' comp cases, so there's a fear of it slowing things down. So that leads up to what happened much more recently, which is an announcement from Medicare that was sent to their contractors that they will reject medical claims submitted post-resolution of a liability settlement on the basis that those claims should be paid from a liability Medicare set-aside. It does say, which is really confusing and possibly good news, is that if there is no set-aside, that they would continue to process those claims. But we really don't know in the end what's going to happen and how these things are going to be handled going forward. But that's created a very kind of shifting area now for us to navigate. But so if you look at all of what Medicare has been doing, they have been laying this groundwork for ultimately establishing formal guidelines for liability settlements. And because of what's going to happen in October of this year with the direction that's been mandated by CMS, we don't really know what's going to happen if clients don't set up set-asides. But there's a lot of things at play here, and in the end, it's something that you have to be concerned about. So when do you need to be concerned about it? If you got a client who's eligible for Medicare benefits or has that reasonable expectation, and if the case funds future medical, and if there's future accident-related care, that's going to be covered by Medicare. So if you say yes to all those questions, then a set-aside analysis should be considered. Again, that doesn't mean that an MSA should be established. It just means that the analysis should be done. So if there is a no to any of those, then what you want to do is write a letter to your file about why you're not doing an MSA, or have a third-party provider like us do an evaluation letter, because you want to cover yourself in the event that that client gets a denial of care down the road and comes back to you and says, you know, why did we not do a set-aside in this particular settlement? And there are no thresholds in terms of the settlement amount. It's applicable to any case with a Medicare beneficiary. Smaller settlements are probably just not worth the concern because the risk and exposure just isn't significant enough. But those cases might be good cases to get a analysis done, an outside analysis, and have a letter that's in your file as to why you did what you did. It just really is a case-by-case analysis. There's no one-size-fit-all answer for these questions. So our philosophy has been to try and reduce the amount that's being set aside through different tactics that can be utilized that are certainly within the letter of the law, because there is no law. There's just things out there that guide us. The apportionment is obviously the number one thing, which is the reduction formula using that Alborn-Benoit type approach. Also, real-world pricing of the medical is important. Aggressively approaching life expectancy, and also using structured settlements to fund any set-aside obligation that is going to be undertaken, are all ways to reduce the amount that's being set aside. So last year we were able to reduce by 80% on average the amount that should be set aside. And granted, a lot of that is based on the apportionment type of arguments. So in terms of best practices for you guys, you really have to start early on controlling this process, because you don't want to let the insurance industry, the defendant insurers, control this at the end of the case, because it will hang things up, it will cause issues. Dealing with it on the front end and being prepared is really the best way to make sure it doesn't slow down the process. You've got to have assistance to identify potential Medicare beneficiaries within your practice, and you want to confirm eligibility for SSD with Social Security. And you want to make sure you're getting copies of insurance and government assistance cards. Obviously, that becomes really important if they're on a Part C plan, so you know that perhaps there's that Part C lien hanging out there. And you want to make sure you know who is potentially Medicare eligible and identify those folks if they're turning age 65, if they're SSDI eligible, if they're in end-stage renal disease, or if they have ALS, or if it's a child that was disabled before age 22 with a deceased parent or disabled parent drawing Social Security. All of those folks potentially are Medicare eligible people that you have to be concerned with all of these issues that I've been talking about. And really, it does boil down in terms of getting these things taken care of at settlement as a collaborative process with the defense. It's not saying you have to agree to everything that they want or try to mandate. What I'm suggesting is opening the lines of communication to make sure the proper Section 111 mandatory insurer data is reported, know the ICD codes, work with the other side about that, get the other side information about Medicare eligibility status, and deal with the Medicare secondary payer release language. And as I said, the ICD codes are very critical. You've got to know what those are. And then if you determine that future medicals are funded, you've got to educate your client on the risks of doing nothing as it relates to the Medicare Secondary Payer Act, and then ultimately select the appropriate MSP solution to protect your client and your law firm, and document the file. You got to document the file. So in summary, you've got to have a process within your firms to determine if future medicals are funded, educate the client, and select the appropriate solution. And the acronym we use is CAD, consult experts, advise the client about MSP, and then document your file. And we have a tiered approach that we offer clients where we can do a consultation service with the client. If they decide they don't want to do anything, we have them sign a detailed acknowledgement that you can paper your file with. And if they decide that they do want protection, we can do an estimate of future Medicare coverage services, which is a cheaper route to go versus a full liability Medicare set-aside allocation report. So the last substantive topic is dual eligibility. So there is a subset of the injury victim population that will have both Medicare and Medicaid. What these clients get are Medicare coverage, which is primary, and then Medicaid supplements and pays parts of the expenses normally that would be incurred by the client. And there's a whole host of different programs that Medicaid provides benefits under based upon assets and income, which are outlined in the slide, which I'm not going to cover. But if a client is on Medicaid and an MSA is going to be established, that MSA is an available resource which would cause ineligibility for Medicaid and SSI. So the MSA has to be inside of a special needs trust if the client is dual eligible. And all an MSA SNT is just an SNT with MSA language included, but it keeps the eligibility intact for those that are dual eligible. And we've developed a very cost-efficient pooled trust solution for clients that are dual eligible that allows them to have two special needs trusts. They have one for the non-Medicare funds, and then they have one for the MSA, which has to be segregated from the other funds. So with the education kind of behind this, I'm just going to give you a real brief overview, a little bit of a commercial for Synergy. Our settlement services firm is really the only one in the country that offers a comprehensive solution to ensure total Medicare compliance. And what that service entails is the resolution of conditional payments and Medicare Advantage liens, audit verification and refund process that I talked about, the MSA allocation reports, funding analysis, and ultimately administration of set-asides. So if you do need help with Medicare, there's a number of ways that we can help you guys. We can audit your case files to identify potential MSP concerns, provide the CYA documents that I mentioned, do CLE training for your firm. We can come in and do a presentation for the members of your firm to make sure they all understand what these risks are. And ultimately, we've got a very easy online process for you to engage Synergy. And what we do overall is we do healthcare lien resolution, Medicare secondary payer compliance, which I talked about, pooled trust services, which are for those that are on needs-based benefits or those that are looking for an efficient way to have monies put into a settlement trust, settlement planning and consulting services, tax deferral for attorney fees, QSF administration, and mass tort lien resolution. So with that, this is the end of the presentation. My contact information is on this slide. We do a lot of consultation with law firms all over the country. We don't charge anything for a consultation. We only charge if we're providing a specific service that you hire us to do. So if you have questions in this area, we're always available for consultation via email or the phone numbers that I've got listed at the bottom of my slide. And I just want to take a moment to say thank you. We do appreciate you taking time out of your busy day to listen to the information that we provided today.